and gentlemen, and welcome to this afternoon's webinar organised by the British Chamber of Commerce in Thailand. My name is Stephen Frost. I will be moderating this event. My position with BCCT is that I'm chair of the Legal and Taxation Committee. The event is the third and final webinar in a series of 3 linked events on debt restructuring. And all of these events have been presented by senior and prominent lawyers with long experience in this sort of work in Thailand. The title of this event is The Plan, Balancing the Interests of the Debtor and the Creditors. Our 2 guest speakers this afternoon are Kun Nati Silachalern, who is a partner at the well-known and long-established local firm of Chandler MHM, and his colleague, Kun Itirot Klinboon, who is a counsel at Chandler MHM, and they both work in the dispute resolution practice at the firm. Both speakers have extensive recent experience of debt restructuring work, advising both creditors and debtors. Most recently, they acted on a number of very high-profile debt restructurings of airlines in Thailand and also in relation to other industries. As I mentioned, Kun Nati is a partner at Chandler MHM. He specializes in dispute resolution, including litigation and arbitration cases, regulatory matters, international trade, corporate and commercial law, and labor and employment disputes. Kun Nati has significant experience in representing both local and international or multinational companies and individuals on various legal and regulatory matters in Thailand, including in relation to debt restructuring. His colleague, Kun Itirot, is also in the dispute and resolution practice. He specializes in representing multinational organizations and business operators in a wide range of litigation and dispute resolution cases, including both civil and criminal disputes, domestic and international arbitration, commercial disputes, insurance and reinsurance cases, and also labor cases. In addition to his 19 years of litigation and arbitration experience in Thailand, he's also completed a special course in reinsurance training at the Singapore College of Insurance. Kun Itirot, in the same way as his colleague, has advised both creditors and debtors in a large number of debt restructuring cases in Thailand. I'm now going to hand you over to our joint speakers this afternoon. They will make their presentations, and then we will move into a question and answer session after that. So over to you, gentlemen.
Okay, thank you very much, Kun Stephen, for introduction. Good afternoon, ladies and gentlemen. Firstly, we would like to thank you for attending to this webinar event, and thank you so much for British Chamber of Commerce to give us an opportunity to share our knowledge and experience about the reorganization proceeding in Thailand. Okay, for this event, today's event, we will discuss mainly about the rehabilitation plan, which would say that it would be most important part of the rehabilitation proceeding because it will be used throughout the period of the implementation of the plan after the plan is approved by the court, which will be about 5 to 7 years. So the today contents for the today we will be discuss about Kun Itirot will discuss about element of the plan, information of the business liability, debt, asset that should be included in the plan, how to classify the creditor and objecting to the plan on the ground of classification of the creditor, and also cover the unfair treatment under the plan and how to prevent typical issue. And then what myself will discuss about the proceeding to the amendment to the plan and also relevant requirement under the law for the amendment and for the creditor meeting, and what is the threshold for the voting for approval of the plan or any voting during the creditor meeting, and then about the right of the creditor to object the plan at the court approval stage, and then the court, of course, will involve with the proceeding at the time. So can I over to you, Kun Ichiro, for the first part, please?
Okay, thank you, Kunati. I think that today we are going to, I think Kunati already advised you already what we are going to present in this webinar. And yeah, that for me, the topics would be I think the element before we go to the element of plan. I think that we should advise. I should present something about the timeline. Yeah, the timeline to submission of the plan to the official receiver. I think that we should be reminded that will be 3 months after the order of appointment of planner published in Thai Government Gazette, and this 3 months can be extended, but extend 1 month each time upon the court approval, but not exceeding 3 months in total. So I think that will be to be reminded that 3 months is very I think it's very crucial, because if we pass, that will be the whole process will be ineffective, and everything that will be done in the previously will be collapsed all the time, all other things. Okay, we jump into the element of plan that we are going to discuss today. For me, I think I'm going to start with because of according to the law section 90/42, we have like we have a code in the bankruptcy that they state the element of the plan into 9 or 10, I think 10 elements. I'm going to cover all of the elements, but some of the element I will give you example what the wording that the planner usually put in the plan. So I'm starting with the reason for the business reorganization. Next slide, please. Yes, okay. For the reason for business reorganization, the example wording which I have come across and review all the plan that submit to the official receiver is the debtor always put it in the plan that that about the reason for business legalization, that the debtor has great reputation and is acceptable among its customer in the market, and the debtor has an efficient business plan to develop the market strategy to compete in business competitor in the market, and also the debtor has a plan to cut off unnecessary expense incurred, and the very important things that the reason that have to put in the business legalization is always that if the implementation of rehabilitation becomes successful, the creditor would recover its outstanding sum more than recovery of outstanding via litigation proceeding in court, arbitration, or bankruptcy. That would be very crucial point that the planner will always put in this element in the plan. Okay, we go to the second one, that the details of the debtor property liability obligation at the time of the court business legalization order. This is that I should explain is that such detail will be in accordance with the balance sheet of the debtor, which have been submitted to the court at the time of the submission of petition for rehabilitation. Because the balance sheet will show the debtor property and liability and obligation. And next slide, please. Okay, we go to the principle and method of business legalization. I think they have, there would be 6 categories which should be considered, but I will go to one by one, but I will give you example and will explain you some of the such categories. I will start with the first one, that step in business legalization, and the second one, the payment of debt, extension of the time for payment of the debt, the reduction of the debt, and the classification of the creditor. The example of the wording that I come across various plans we submit to the official receiver is that this element, the payment of debt and term of payment and reduction will be made pursuant to each classification of the creditor under the plan, and the classification of the creditor will be discussed in next slide. That will be covered by me, how to classification the creditor in the next slide. And the third one is reduction of increase of capital. And the fourth one is that creation of debt and raising fund, including source of fund and any condition pertaining to such debt and fund. And this is element the planner will indicate that for the purpose of implementation of the payment of the plan, the debtor will apply the loan from the financial institute and commercial banks. That will be to give the trust and belief to the creditor that they will have enough money to pay them back. And the fifth one is that management acquisition of benefit from the asset of the debtor. And the sixth is a condition regarding payment, dividend, of other benefits. And next slide, please. Okay, we go to the next element, which is redemption of security in case where secure creditor and liability of the sureties. I think the example of wording in the plan of such element is that the debtor agreed that any collateral with the creditor is still ineffective, and the creditor will hold such collateral for its guarantee for the payment until the repayment of debt has been made completely according with the plan. And accordingly, if the payment has been made completely under the plan, the creditor will redeem such collateral to the debtor immediately. That would be in state and stipulate in the plan. Okay, we go to another element. The way to solve the problem in the event of temporary of like liquidity in the course of implementation of the plan. I think this is the most important that the planner will put in this clause and wording in the plan to make the creditors to believe that, to trust that they will have enough money to pay them back. Such example of such wording is that the debtor will use its effort to negotiate with the financial institute or commercial bank to obtain such sufficient loan to solve its lack of liquidity of cash shortage. And the other one is always the debtor will use that. The debtor will cut off its unnecessary expense to solve its lack of liquidity and cash shortage. And the other one that, yes, of course, the debtor will negotiate with the financial institute and commercial bank to obtain the new money for running its operation further. Okay, we go to the another element, that the practice to pursue and the event of assignment of the transfer of the debt. And the example is that it's very simply that the debtor would include that if the creditor assigns claims under the plan to any parties, the creditor and the assignee are required to give the written notification to the planner in according with the law. And next slide, please. Okay, So this is the other element that the name and qualification and the letter of consent of the plan administrator and remuneration, which, yeah, and the other one is the appointment of the plan administrator and its termination. Okay, I'm going to discuss about the termination, termination appointment of plan administrator. Because the termination of appointment, the appointment of plan administrator will be terminated after the rehabilitation is successful. But sometimes the rehabilitation will not become successful, but the implementation periods of rehabilitation plan have been expired, but it has not been successful yet. So that they have to the appointment of plan administrator will be terminated as well. And the other, that according to the law, that if it seems that if after the implement of the plan administrator is dead or under absolute receivership, there will be the appointment of plan administrator will be terminated as well. Okay, for the next one, for the time for implementation. Okay, for the time for implementation, we shall not exceed 5 years. At that, and the 5 year can be extended twice for the maximum of 1 year each. Okay. So the other one, I think the last one for that I'm going to discuss about the element is that the refusal of accept the debtor property and contractual right in case of debtor property or contractual right bearing unreasonable greater burden than benefit should be derived therefore. I think the short explanation is that this is I come across to the TG and no rehabilitation plan. The plan, I think the good example from that plan is that the plan states that the airline which terminate the lease agreement and return the aircraft to the lessor with the reason that the aircraft has no longer required for its business operating. If it compared to the rental which the airline are obligated to pay under the lease agreement, that will cut the loss of the airline and they can operate the business further. Next slide, please. Okay, we go to another one that so we passed the element of the plan already, and we are in the topic of information and business liability debt and asset which should be included in the plan. Yeah, okay. So at that point, it's very important to obtain all business liability and debt to the plan. This is because the court will also rely on this fact to consider whether the plan should be approved. And the other one is that we said the liability should be conclude of any right against claimable and liability and against claimable any third party. Okay, and the other one is that the debt must be included of any debt that have been occurred until the date of the court rehabilitation order. And go to the next slide, please. Okay, so this is another topic I'm going to cover today is that how to classify the creditor. Because we, under our law, we have our Thai bankruptcy law, we have section 90/42 bits that the planner will classify the creditor into the following groups. The first one is number one in the slide, that the secured creditor which each secured credit will up with the amount of secured debt being not less than 15% of total amount of debt. And for definition of secured creditor is not stated in that section, but it's in another section of the bankruptcy, and I put it in my note, and the secured creditor under bankruptcy means the creditor having right over the debt, property and mortgage, bridge, and right of retention. And the example, the good example that for security is easy, that simply is mortgagor and the pledgor under the mortgage agreement and pledge agreement respectively. Okay, and the other group that the second one, that is another group of the creditor, the secured creditor not classified in the above group. And the third group is unsecured creditor. Unsecured creditors is that, for example, the claim, the trade creditor or the lessor and the tax authorities. And this is not secure, so we put in unsecured in the other group, in the third group. And the fourth group is subordinated creditor under section 130 bits of Bankruptcy Act. Next slide, please. Okay. This should be note that within such classification, there may be more than one group of the creditor, depending on the number of the creditor and amount of debt. And the very important that the planner have to be in mind that the planner must treat all the creditor within the same classification equally for the purpose of the business rehabilitation plan. This is very important that the plan have to be in mind that they have to treat all the creditor with the same group equally. I will discuss with the plan does not follow this principle, what they have, what they should be faced the problem. Okay, next slide, please. Okay, that's what I'm saying, that if the planner does not follow the treat of equally for in the plan, if the creditor view that the classification is not in accordance with above criteria, I mean above group that I just said, the creditor can file the petition to the court within 7 days from the date he acknowledged the classification. And after the court get the petition, the court may order the classification of the creditor promptly. And you have to note that such order is considered a final. Okay, we go to next slide, please. Okay, this topic, unfair treatment under the plan and how to prevent the typical issue. This is the one that I'm going to discuss with you, that the unfair treatment is occur when or more creditors in the same group have received more favorable treatment than the others. The example is this principle is very simple, is that if in the plan state that the outstanding sum of company A in a secure creditor group would be settled in 2 years, but in the other hand, the outstanding sum for the company A, B in the same group would be settled in 3 years. This is the example that company B can submit the petition to the court to object the classification, and sometimes they can make the amendment of plan under the method of unfair treatment. And I think that in order to avoid typical issue, the planner must avoid any favorable treatment and provide privilege to any creditor in the same group. And next, I think that would be, I cover all the topic that I'm going to advise you today, and I will show this to Kunati to cover the topic about the next slide. Next slide, please. Okay, about the amendment of the plan and relevant requirement that have to be done for in the rehabilitation plan. Okay, Kunati. Kunati, you open the mic. microphone.
Yes, thank you very much for this note. Yeah, I'm on mute. Okay, now we are talking about the amendment to the plan. Apart from the right of the creditor to object the classification of the creditor, as Kun Ichiro just present, all creditor, including the debtor and planner, are also entitled to propose an amendment to the plan as well. The request for the amendment to the plan must be submitted to the official receiver at least 3 days before the creditor meeting date. So if they submit only 2 days, so it will be dismissed by the official receiver. In the request, the creditor should specify a reason and clearly propose and amend wording to the plan so that other creditor can understand your proposed amendment easily and may vote supporting your proposed amendment if they agree. So you can request to amend any parts of the plan. Normally, the creditor would focus on the repayment term and condition because they always wish to get a repayment amounts as much as possible and as fast as possible. However, if the proposed amendment to the plan is to change the plan administrator, a letter of consent from the nominated person as the plan administrator must be submitted together with the request. And it should be noted that the person proposed as the plan administrator must meet the qualification under the relevant law and be registered at the Office of Legal Execution Department, unless such a person is an executive of the debtor. There is one example, the requirement of the registration as the plan administrator is similar or same as the planner as well. In Thai Airways case, one creditor tried to request the court to add them as the planner, but actually he is not registered at the legal execution department. So the court dismissed his request. Yeah, similar to this. So the plan administrator, if they are not the executive of the debtor, they need to be registered. Right. Next slide, please. Okay. After the plan is submitted to the official receiver, the official receiver shall deliver the copy of the plan to the debtor and creditors and convene a creditor meeting to approve the plan as fast as possible. Normally allow 2 months after submission of the plan. However, for this current situation, it might be longer due to the COVID-19 situation. And in the creditor meeting, normally it shall be conducted physically. However, this year, we can see the new proceeding to conduct the creditor meeting because of COVID-19 situation. The legal execution department allow the creditor meeting to be conducted virtually. For example, both Thai Airways case and No Airline case, yeah, both of the cases conduct a creditor meeting virtually, right? In the creditor meeting, the official receiver will be the one who conduct the meeting and will be the chairman of the meeting. The voting right of the creditor will be based on the amount of debt that granted by the official receiver for the repayment. However, if the official receiver cannot make a decision on the debt claim before the creditor meeting date, the Bankruptcy Act empowers the official receiver to determine the voting right for the creditor. Such determination of the official receiver is final. However, it will have a specific effect on the creditor meeting only and not affect the creditor right to receive the repayment of debt. Now we may talk a little bit about the agenda of the creditor meeting would generally be like to consider and approve the proposed amendment to the plan proposed by the creditor or the planner one by one, and then to consider and approve the plan, the whole plan, which will be include the amendment as approved by the creditor meeting as well, right? And then after that, we'll consider nomination of the creditor committee, right? Okay, in case the creditor meeting approve any proposed amendment to the plan, the official receiver will ask the planner whether the planner agree to the amendment as proposed by the creditor meeting, as approved by the creditor meeting. If the planner agree, the amendment will be incorporated into the plan and will be further approved by the creditor meeting. Next slide, please. Okay, now we talk about the vote in the creditor meeting. There will be two kinds of resolution for the creditor meeting, which are normally resolution, normal resolution and special resolution. The normal resolution is required more than like 50% of the total debt value of the creditor who attend the meeting and cast the vote. For this normal resolution will be used for approval of any matter rather than the approval of the whole plan or maybe as amendment. For example, to approve any proposed amendment to the plan. Okay, for approval of the whole plan, the plan must be approved by special resolution, which is one of the two thresholds. As you can see in the slides, the first threshold is, I would say, is very difficult because it require this vote from every class of creditor or each class of creditor, which is require 2/3 of the total debt of creditor who attend the meeting and cast the vote, of course. And majority of creditor, this is about head count of the creditor, yeah, from every class, as I said. So it will be very difficult. Sometimes, like in the Thai Airway case, they have like 35 group or class of creditor. So if it requires 2/3 of the total debt of creditor in each class, or even majority of creditor in each class, it will be very difficult to get it, right? So maybe the most case will be for the second threshold. Next slide, please. Okay, this second threshold is much easier to get it, right? Because it requires only one class of creditor to approve. Like this, like one class of creditor have vote like 2/3 of the total debt value of creditor and majority of creditor from every class, from only one class. But this second threshold require 50% of the total debt value of all creditor who attend the meeting and cast the vote as well. So you can see, as I said, that this threshold will be much easier than the first threshold. Yeah, and in most of the case, the plan will be approved by the creditor meeting by using this passing this resolution. Okay. Next slide, please. Okay, under the Bankruptcy Act, the creditor meeting may vote for nomination of the creditor committee to help monitor the compliance of the plan instead of creditors. The creditor committee will consist of 3 to 7 persons. The nominated person can be either the creditor itself or its representative, but one creditor can have only one representative in the creditor committee. In practice, after the creditor meeting passed the resolution to approve the whole plan, the official receiver will ask whether the creditor would like to nominate anyone as the creditor committee. If there are less than 3 persons are nominated, there will be no creditor committee as it doesn't meet the requirement under the law. For example, in NOC airline case, there will be no creditor committee because only 1 or 2 persons nominated as a member of the committee. So it's not meet the requirement. But in other case, like if there is more than 7 persons are nominated, the official receiver will ask the creditor to cast the vote. The first 7 persons who get the highest vote will be nominated as member of the creditor committee. This happened in the Thai Airways case. There are about 10 or more persons are nominated and only 7 persons can be nominated. Okay, next slide, please. Okay, once the creditor committee approves, once the creditor meeting approves the plan, the official receiver will report the resolution of the creditor meeting to the court together with its written opinion on the plan. The hearing date for consideration and approval of the plan by the court will be fixed. And on or before the hearing date, the creditor who did not vote to approve the plan is able to submit an objection to the plan with the court. In other words, if you vote disapprove or abstain, or even you did not attend the creditor meeting, you are entitled to submit the objection to the plan to the court. Right? Next slide, please. Okay, what are the key considerations by the court for approval of the plan? If you can see in the slides, there will be 3 key considerations. The first one is the plan contents are complete, like particular is like that contain all the elements required by law as Kun Ichiro present earlier, right? However, even if some elements are missing, but the court consider that such elements are not material for the rehabilitation proceeding or the implementation of the plan, the court may deem that the plan contains all elements, right? And the court will ask the planner about the reason why some element missing as well, and taking that into consideration. Okay, the creditor, second one is the creditor in the same class are treated equally, of course, as mentioned by Kunichiro. And the third one, after the plan is accomplished, the creditor will receive the debt repayment higher than in the scenario where the debtor is just bankrupt. These are all the elementary. However, those 3 key considerations of the court are just a minimum requirement for the court to consider under the law. It doesn't mean that if the plan meets those 3 requirements, the court must approve the plan. So the court may take into consideration other issues as well, especially about the lawful and maybe about the good faith. Okay, I may give you some example, like whether the creditor meeting was conducted lawfully, the voting of the creditor is counting like correctly, there is any error on the counting of the voting or not, something like that. If there is a objection by the creditor and the creditor have some evidence to support that the court have to be taken into consideration before approve the plan. Second one, like whether there is an opportunity for the plan to be successful, whether the plan is made in good faith or not contrary to the law relating to the good moral or public order, whether any condition under the plan is lawful or not. Yeah, that any issue that the court consider that is important for consideration for approving of the plan, the court can do so. Okay. In considering the plan, the court will consider the official receiver opinion on the plan, explanation of the planner, and all objection made by the creditor altogether. If all the requirements are met, the court will order approval of the plan. If it is possible, it may be possible for the planner to request for amendment to the plan before the court making decision. If it is a minor amendment, the court may grant such an amendment. However, if it is a material amendment to the plan, and the court consider that the amendment is necessary for rehabilitation to be carried on, the court may order the official receiver to reconvene the creditor meeting to consider and approve the amendment. In this case, the court has no power to make a decision on the material amendment to the plan, as it is the power of the creditor meeting. So that's why the court ordered the official receiver to reconvene the creditor meeting. Okay, next slide, please. Okay, if the plan is approved by the court, the plan administrator will then commence that the duty to proceed with the implementation of the approved plan and have the power to manage the debtor business. Right? If the court does not approve the plan, the court will order to revoke the rehabilitation order. And as a result, the automatic stay will be lifted and the managerial power of the debtor executive will be resumed. And if there is a bankruptcy case against the debtor is already submitted to the court, to the bankruptcy court, the court may order to continue such a bankruptcy case against the debtor. Okay, that should be all for today. Thank you very much.
Okay, thank you very much indeed to our two guest speakers today. I see no Q&A has come up so far, so perhaps I can try and start the ball rolling a little bit. I'm very interested in what Kunnati said about possible hiccups and difficulties that might occur. Based on your recent experience of cases during the current difficulties, where do you see most difficulties occurring? For example, is it between different classes of creditors, or is it between creditors and the court? The court is not particularly happy with some aspect of the plan. Where are you seeing areas of difficulty and concern based on your recent experience?
Okay, I would say that the most difficulty is about how to make a repayment condition that will be acceptable by the creditor, right? As I said, the creditor would like to get the repayment of debt as much as possible and as fast as possible. So if they cannot get what they want, so they will try to make an objection to the court, and then if it is obviously that make it unfair between creditor and creditor, so the planner have to explain to the court why they treat the creditor, even if in the different group, why they treat unequally, right? So if they have a very good answer to this question, so the court will take it into the consideration, and maybe the plan can be approved by the court. So I would say that about the repayment term would be very difficult, very difficult for the planner to make it agree by the creditor.
Okay. move on to something slightly different, again, based on your recent experience. An outsider may think that restructuring cases are largely about airlines and hotel chains and restaurant chains. I don't think that's exactly the case, is it? Because the COVID crisis has caused so many areas of service businesses and also, of course, manufacturing businesses to be severely distressed. Without naming client names, obviously, what are you seeing? What are the sorts of businesses that are seeking the protection of the court through restructuring?
Okay. I think it will be like most likely will be about SME case because SME business because it's quite they have no like long term or like what can I say? They have not much money to survive during the COVID-19 situation, right? And especially about the policy of the government that have the like curfew and close down of some business for some period of time, which affect to their business a lot. So that might affect to their business, especially the hotel, restaurant, and especially we also represent one of the creditor who is in the business of automotive, right? So in that case, they have been like directly affected by the COVID-19 situation. Yeah. Kunitilo, do you have anything to add about this? Maybe you are on mute.
No. Yeah. Sorry. I think that I agree with Kunati that the case that would be the court will treat as an SME business that because I think I agree that they have not enough money to pay off the creditors, so they have to treat better than the other business operations. Yeah.
Okay. Taking into account we're in September 2021 now, well, passing into October tomorrow. For how long do you think that there's going to be continued activity with companies wanting to apply for permission to restructure? I mean, are things going to go on as long as some of the cases 20 years ago in the Tom Yam Goong crisis? Or do you see, what is the key to this? Is the key economic recovery, quite frankly, so that companies they're able to bank more money, they're becoming more liquid? How long do you think this will go on for?
Okay, thank you. I think if I think the government try to like open the country and try to release the lockdown policy as fast as possible, as soon as possible, maybe for tomorrow, right? There will be release of the lockdown period a little bit, and also the quarantine period will be less than 14, so become 14 days become 7 days, right? And if we got the higher percentage of vaccination enough for opening the country, so I think in November maybe we can open the country and all the business can be open as usual. So if the SME or any business that affected by the COVID-19 can survive until now, I think after November they will be okay. Especially, for example, like airline, hotel, restaurant, especially airline. If the country is open, the airline business, I think will be much recovered than the past year. Right, last year or this beginning of the years, right? So in my view, we can see like a high change beginning of next year. I would say it would be much better beginning of next year.
So if I could use a British expression, Kunnati, you do see the green shoots of recovery starting to come through the ground, through the earth.
Yeah.
Okay, well, that's great. Okay, no Q&A has come through. Unless, would either of our two speakers like to make any concluding remarks?
Okay. Okay, if maybe the audience is something like from relevant industry in relation to the business reorganization, like audit firm or law firm. So you can see that this year is very high profile case like Thai Airway case and No Air case. There are many issues come up during the proceeding, but they try to solve the issue quite good and in a good way. And the court also would like the debtor to proceed with their operation, which will be good for employee to still have the work on the business. Otherwise, we'll be unemployed for a lot of people, right? We'll be unemployed. So we can see for the trend of the court that the court try to make it possible as much as possible to help the business to be continued. And that will also benefit for the creditor to get the repayment of debt rather than the debtor become bankrupt. Right? So yeah, I think it will be good sign to see that okay, business reorganization proceeding will be one of the way for the business to be survived. Okay, thank you. Kunichiro, do you have anything to add?
Nothing from me.
Okay. All right. Well, can I bring matters to a close then? On behalf of British Chamber of Commerce, I'm very, very grateful to Kunnati and Itirot for preparing such a detailed and succinct presentation, centering and concentrating on the plan. What should go into the plan? How can the plan be amended? How is the plan approved? This is something that may be, to some extent, a mystery to many lay people in particular. So much thanks indeed from the British Chamber to our two distinguished speakers. And can I say to people who didn't join the presentation today, that Chandler MHM's slides will be uploaded and will be accessible from the British Chamber website from tomorrow onwards. So for people who weren't able to join in the webinar this afternoon, don't worry, you can still download the presentations, and I'm sure that Kunnati and Itirot would be pleased to answer emails from you to clarify any issues with regard to the plan and its contents in particular. So thank you very much to both our distinguished and experienced speakers this afternoon. And that's all from me for the moment. Thank you very much.
Thank you very much, Kun Stephen.
Okay.
Thank you very much.
Yeah, have a nice. Yeah, have a nice.
Thank you.
Thank you.